3 a.m. You're asleep. Your wife is next to you. Your kid is down the hall. And then, boom! Your front door explodes off the hinges. Flashbang grenades detonate inside your home. Armed federal agents are screaming, dragging you out in handcuffs, pointing weapons at your family. And then, one agent spots a piece of mail on your coffee table. Wrong address. Wrong house. They got the wrong house. And when you try to sue the federal government for what they just put your family through, they tell you you can't. That case just reached the United States Supreme Court, and the court came back with a 9-0 unanimous decision, every single justice. And now the case is dropped back down to a federal appeals court, and what just happened in those new arguments may have changed everything. Let me take you back to where this all started. 2017, suburban Atlanta. A family is asleep in their home before dawn when FBI agents show up to execute a search warrant. One of the agents, instead of using the official address documentation, punches the warrant address into his personal GPS. The GPS routes him to the wrong home, nearly a full block away, to the house of a woman named Katrina Martin, her boyfriend, and their 7-year-old son. The agents didn't double-check, didn't verify. They stacked up on the door and went in hard. Flashbangs inside the house. The couple, hiding in a closet, were ripped out at gunpoint. She was barely dressed. Her boyfriend was handcuffed on the ground. Their young child was pulled out too. Then one agent noticed something. Mail on a table. The address didn't match the warrant. That was the moment they realized what they'd done. They released the family, told them they'd come back to explain, walked down the street, and executed the actual raid on the correct house. The family sued the federal government under a law called the Federal Tort Claims Act, the FTCA. It's one of the main legal tools regular Americans have to hold the federal government accountable for its agents' mistakes, but the government fired back with a legal shield called the discretionary function exception, essentially arguing our agents were making judgment calls during that operation, and judgment calls are protected. Case dismissed. The lower courts sided with the government, twice. But here's where it gets interesting. The Supreme Court agreed to hear it, and in a ruling that sent a clear message, all 9 justices agreed the lower courts got it wrong. The government doesn't get automatic immunity just because a law enforcement officer exercised some form of judgment. The Supreme Court made it clear, to qualify for that protection, the government must prove those decisions were rooted in genuine policy considerations, not just mistakes dressed up as discretion. That's a massive distinction. And with that, the Supreme Court sent the case back to the 11th Circuit Court of Appeals to apply the correct legal standard and take a fresh look at the facts. That rehearing just happened, and the oral arguments revealed something significant. The judges on the 11th Circuit were clearly skeptical of the government's position, and they weren't shy about it. The central question driving the entire argument was this: at what point does a law enforcement mistake stop being a protected policy decision and start being plain operational negligence? One of the sharpest moments came when a judge essentially challenged the DOJ with this: if getting the wrong house on a federal warrant counts as protected discretion, then what wouldn't be covered? Because under the government's theory, almost any mistake an agent makes during a raid could be reframed as a judgment call. And that would mean near total immunity for the government in almost every wrong house scenario imaginable. The judges weren't buying it. The government's argument during the hearing was that everything, the surveillance, the navigation, the execution of the raid, all involved discretionary choices. And because no specific written rule told agents exactly how to verify a home address before breaking down the door, they argued the discretionary exception still protects them. But one judge fired back with a point that cut right through that argument. Almost every human action involves a choice of some kind. If choice alone equals discretion, then everything is covered, and nothing is ever the government's fault. That's not what the law was designed to do. The family's attorneys kept it simple. Identifying the correct house on a warrant isn't a policy judgment. It's the bare minimum. It's not discretionary, it's mandatory. And the panel seemed to track with that logic far more than the government's position. Now here's the update you really need to pay attention to. At the close of arguments, the court told both sides it would let them know within about a week if it needed additional written briefing on how the Supreme Court's ruling affects the negligence question in this case. That window has now passed. No order came. No additional briefing was requested. That silence speaks volumes. When a federal appeals court says it might need more information and then doesn't ask for it, that typically means the judges already feel they have enough to decide. It means the court is likely moving directly toward a ruling on the merits. No delays, no extra rounds. They're ready. So what are the realistic outcomes here? The most likely path, based on everything that came out of those arguments, is that the 11th Circuit rules in favor of the family and allows this lawsuit to move forward. The court may formally hold that the discretionary function exception simply does not apply to something as fundamental as identifying the correct address on a federal warrant. That's not policy, that's not strategy, that's basic competence. There's also a possibility the court sidesteps the broader FTCA question entirely and rules more narrowly, finding that raiding the wrong house is such a clear and obvious error that it falls outside any reasonable definition of protected discretion, full stop. Either way, the government is in a far weaker position today than it was before the Supreme Court stepped in. And here's why this matters beyond just one family in Georgia. If the 11th Circuit allows this case to proceed, it puts a real limit on how far government immunity can stretch. It sends a message to federal law enforcement agencies that wrong house raids are not a consequence-free mistake, that families who are terrorized in their own homes by agents who can't confirm an address have legal recourse, and it sets a precedent that could ripple through courts across the entire country. Right now, the ruling is coming. The briefs are done. The arguments are over. The judges are deliberating. This case started with a GPS error and a piece of mail on a coffee table. It's ending at one of the most consequential crossroads between government power and individual rights that we've seen in years, and the moment a decision drops, we'll break it down for you completely. Make sure you're subscribed so you catch that update the moment it goes live, because this one matters for every American who believes that accountability has to mean something, even when the government is the one who made the mistake.